A lot of people are on a jury for the first time, and they are thrown into the room and told, hey, go in there and please come out with a verdict.
It's very difficult as a defendant to sit at the table and do the right thing. Do you make eye contact with them? If you make eye contact with them, do they get afraid of you?
And if we're ultimately trying to get to the truth, I think folks with diverse opinions get us there faster than folks without.
I'm Julie Rose, and this is Top of Mind. I have been a radio journalist for 2 decades, but a few years ago, I found myself avoiding the news for long stretches because of how depressing and divisive it all seems. I still wanted to be informed and engaged on important issues, though, and I figured I couldn't be alone in that. So we created this podcast. Each episode, we tackle one tough topic in a way that will challenge you, help you feel more empathy, and empower you to become a better citizen, a kinder neighbor, and a more effective advocate. Today, trial by jury is a constitutional right. But do juries work the way we think or hope they do?
My jury service really complicated my ideas of the world, my ideas of community, my ideas of democracy in ways that were really profound.
Kristen Campbell served on a jury in Washington, D.C. in 2011. It wasn't what she expected.
What I wanted to be able to walk out of the courtroom and say was, "You are welcome, Washington, D.C. I made your streets incrementally safer today. You are welcome for my service." And instead, I walked out, I started crying my eyes out, and I walked 19 blocks back to my office, and I could not stop crying the whole way. We ended up finding our defendant guilty. It was a very rigorous, very difficult process, and we didn't feel good about it. We know that we did the right thing for the process, but it still sucked, right? It was not great to sit in judgment of a peer and pass a conviction on him for a mistake that he made. It was what was required of us, and it didn't feel good.
Each year, 32 million Americans get a jury duty summons in the mail. Trial by jury is a key piece of our justice system, explicitly enshrined in the 6th and 7th Amendments of the Constitution. But most of us dread getting called to serve on a jury. I know I did. I was summoned about a decade ago, and I was really hoping to get dismissed. I mean, who would want a cynical journalist on their panel, right? But I was chosen anyway. It was not a positive experience. It felt like we didn't have the information or tools as a jury to make the right decision. Ultimately, we made what I felt was the wrong one, and I wasn't the only person on the jury who felt that way. I'll share more details of my story a bit later in the episode, but I think it's important for you to know right up front that experience has haunted me for years and left me with a lot of questions, a lot of skepticism about why we deliver justice this way. Not all countries do use citizen juries, and the ones that do generally don't give them quite as much power as America does. And yet, even here in the United States, juries are becoming rare. Only 2% of criminal trials ever make it in front of a jury because prosecutors pressure defendants to take plea deals as a faster, cheaper alternative to trial. Should America continue to lean away from juries like this, or press to make them more present in our system and perhaps more just? When Kristen Campbell got called for jury duty, she didn't dread it like most of us do. She spent her career working for philanthropic organizations to promote civic engagement, so serving on a jury was right up her alley.
Also, having been called twice before and having not been selected, I was very curious.
The defendant in her case was a 21-year-old African-American man who was charged with possessing drugs with an intent to sell while also being armed with a gun. She remembers the jury had an even mix of men and women, a range of ages, and was racially diverse. And those are important details because in the United States, we think of a jury as a microcosm of the community it's drawn from. You might have heard the term jury of peers.
But I remember thinking when we were sitting in that room, am I this young man's peer? We live in the same community. We walk the same streets. We have some shared life experiences by virtue of living in proximity to each other. Does that mean that I'm your peer? Our life experience has been very different. And that's obviously a huge assumption. I don't know very much actually about this young man's life experience. But statistically speaking, I at the time was a 29-year-old white woman with a upper middle class job. And this was a 21-year-old Black man who I found out later, was the 6th time he had been brought up on charges. And so it really did make me question, am I your peer? Are other people here your peers? And what does it mean to sit in judgment with a jury of your peers?
When it came time for the jury to deliberate, Campbell says they took an initial vote. And on the charge of drug possession with intent to distribute,
12 hands went up. It was unanimous immediately. We were all very clear that it was possession with intent to distribute.
But they still had to decide whether or not the defendant had a gun, which would make the sentence more serious. They took a vote again, and this time it was split.
I raised my hand for not guilty on that one because I just had so many questions. I just wasn't sure. And I felt that to say guilty, I had to be very, very sure.
She says the defendant said that the gun wasn't his. He'd been a passenger in a car where the gun was found. The vehicle wasn't registered and didn't have a license plate. Police officers pulled the car over and they searched it.
Our defendant steps out of the car. The gun allegedly has slid from under the seat to the floorboard where our defendant was sitting. When the door opens, what he does is he takes his jacket and he drops it on top of the gun. And the whole question was, did he know there was a gun in the car? I remember sitting there and deliberating with the jury, and everybody was interrogating and questioning, what about this? What about that? Could that have been possible? What if it had happened this way? And somebody said, are we overthinking this? And somebody else said, this person's liberty is hanging in the balance. We cannot overthink this.
Campbell and the jury deliberated for half a day, and ultimately they found the man guilty of possession of drugs with intent to sell and having the gun. She says the process was painful and imperfect, but
one of the things that I think is beautiful about a jury experience is the fact that there can be 12 people that can be and are so different in so many ways. And that diversity, I think, actually sharpens the analysis process. It forced us to interrogate biases that some of which we consciously knew we had and others we didn't. Everybody was taking it very seriously and asking questions and pushing each other, but not trying to persuade or change anyone's mind in service of their agenda, but to do it in service of the truth. And I'll never forget, as the foreman was filling out the paper, you could have cut the tension with a knife. I've never felt anything like the sense of heaviness that fell on the room when we reached that decision. And there was somebody who said, y'all, if you don't do anything else when you leave here today, can you please go volunteer somewhere? And somebody else said, yeah, I can't help but think if we had spent the last 4 days in our community instead of in this courtroom, could we have prevented something like this from happening? I have chills right now just repeating this story to you because it was the collective responsibility. This young man made a decision. He needs to be held accountable for that. And what's the accountability that the rest of us have to our community to make it a safer and better place? We were unanimous. We know that that was the decision that we needed to make. And I think many of us felt our own sense of guilt in finding and ruling on the guilt of another person. And it's so much more nuanced than Anybody can understand that hasn't been through the process, and the ways that compromise and diplomacy and power and lived experience are wielded in a group of 12 people charged with passing judgment on a peer is incredible.
Kristen Campbell, thank you so much for your time today. I really appreciate it.
Thank you, Julie.
Kristen Campbell is CEO of Philanthropy for Active Civic Engagement, an organization that works with philanthropists to develop programs that encourage civic engagement. If sitting in judgment of a stranger is challenging, what is it like on the other side of the table?
It's very difficult as a defendant to sit at the table and do the right thing. Do you make eye contact with them? If you make eye contact with them, do they get afraid of you?
That's next on Top of Mind. I'm Julie Rose. Hey friends, I would like to take just a moment and introduce you to another show from the BYU Radio family of podcasts. It's The Lisa Show. Lisa Valentine Clark is the host. She's a comedian, actress, believer, single mom. And the show delves into the multitude of challenges that shape our lives, whether it's parenting, mental health questions, social issues. Lisa and the Council of Moms will tackle it and do it with a lot of laughs along the way as we attempt to figure out this thing called life. So check out The Lisa Show. Listen wherever you get podcasts. Many of us think of the right to a trial in front of a jury of our peers as an important protection against corrupt or unjust prosecution. And that is certainly what Herman Lindsay was counting on.
Because I didn't commit the crime, there's no way I felt like a jury would actually convict me of something I didn't do.
In 2006, Lindsay was charged in a cold case murder that happened 12 years earlier. Rumors circulating among some men in jail led police to arrest Lindsay without any hard evidence or eyewitnesses. Lindsay maintained his innocence from the very start, and he turned down an offer from prosecutors to plead guilty in exchange for a 3-year prison sentence. I'll take my chances with a jury, thought Lindsay.
I had very great faith in because I just couldn't see it happening. How can you convict somebody of something and they didn't do it? So I didn't think it was actually possible. And I was very devastated when they did.
Early on in the trial, Lindsay began to suspect he'd misjudged his chances. The prosecution and defense were weeding out potential jurors one by one in a process called voir dire.
Every person that we thought was great for the jury was ended up being struck by the judge or struck by the state attorney.
In selecting a jury, each side can dismiss or strike a certain number of potentials without cause. Lindsay noticed the prosecution was cutting a lot of people who might be more inclined to believe his defense.
If you get the working class, they most likely don't pay attention to the news and the issues that's at hand with our criminal justice system unless it affects them or their family member. So those was the type of people that actually believe that whatever the state or the police say is what it is. And then you have people that, actually had family members affected by the criminal justice system that we wanted on because they understood that the police can lie. The state attorney is not always right. And most of those got dismissed off the case.
So when the jury is fully seated, at that point, you're feeling like they've dismissed a lot of the people that would have been sympathetic to you. How did you feel at that point? I mean, were you worried?
Well, what made me worry was the way some of the jurors was looking at me. It was very uncomfortable because it's like when the first piece of evidence that the state put on was this horrendous, worst picture of the victim at the crime scene on a big projection screen, and let the picture sit there 2 hours, like almost 2-3 hours, while the medical examiner explained the cause of death, which is one single shot to the head. And the way the jury looked at was like those ones that look at that picture and look over there at the defendant and like already felt like they got the right person. They arrested him, they got the right person. So it's like they drew a conclusion from the beginning.
Yeah, I can't imagine. Did you make eye contact with him?
Actually, that's the thing. As a defendant, you don't know what to do. Because it's like, if you do, it's this way. If you don't, it's that way, the jury thinks. So it's very difficult as a defendant to sit at the table and do the right thing. Do you make eye contact with them? If you make eye contact with them, do they get afraid of you?
And if you don't make eye contact, then maybe that means
you're guilty, right?
Yeah.
So it's so many things that that's a disadvantage for the defendant when it's coming dealing with a jury.
Did you feel like they were a jury of your peers? We sometimes hear that, that you're entitled to a jury of your peers.
There is no such thing as jury of your peers. Maybe if you're in the upper class, you may end up with a trial with juries of your peers. But when you talk about jury of your peers, the middle class and the upper class don't understand what the lower class is going through. They don't know the things that goes on in the neighborhood, and the fact that the police plant evidence, the fact that the police don't do the right investigation all the time, that expert witnesses aren't always truthful. The lower class sees this because they are affected more by the criminal justice system now. So when you say my peers, you can't get a jury of your actual peers.
There's evidence to back him up. First of all, millions of people who get a jury summons each year just don't show up to even be considered for a jury. And who's more likely to skip out? Well, often it's people with low-wage, hourly jobs that don't offer paid time off for jury duty. So that's one thing. Secondly, potential jurors are typically drawn from voter registration databases, and people of color have historically faced economic and geographic barriers in registering to vote. They're less likely to be on those lists, thus less likely to be summoned. Furthermore, while it is illegal to dismiss someone from a jury based solely on their race, studies show Black jurors are more likely to get removed in the voir dire process than white jurors are. The jury in Herman Lindsey's trial was unanimous in declaring his guilt. They were split 8-4 on whether to sentence him to death, but in Florida at the time, juries didn't have to be unanimous in sentencing decisions. As an aside, it might surprise you to know that juries were not required to be unanimous in many states until a Supreme Court ruling in 2020 outlawed split jury verdicts for people accused of serious crimes. So Herman Lindsey landed on death row, where he spent 3 years before his appeal came before the Florida Supreme Court. And there, he had no jury, just a panel of 3 judges.
The judges was actually attacking the state, asking the state, and getting frustrated with the state, saying, where's the evidence? What evidence presented says Mr. Lindsey was at the scene? What evidence was presented to say Mr. Lindsey was participated in this?
Were you relieved that there was no jury?
Yeah, I think I would have been very, very, very afraid if it was another jury there at that time.
The Florida Supreme Court ruled there wasn't enough evidence to convict Herman Lindsey, and they set him free in 2009.
Florida's 23rd death row exoneree. And the thing about it is, I never got compensated. I never got an apology.
Do you think that juries are the best way to decide guilt or innocence in the American justice system?
I believe that I'd rather have a jury than a judge. And
okay.
I think that one of the ways to fix our jury problem is to educate them in the process. When you're dealing with a crime, judging somebody's life, whether they're guilty, I think you need to know that the state has the burden of proving beyond a reasonable doubt. What evidence was presented that Herman Lindsey intentionally killed this person, right? Don't be assuming, And the only way we gonna get to that point is if we educate people who are potential jurors. And that's one of the things I like to speak on and tell people about my story because everybody is a potential jurors. And I think what happened there was that our jury was undereducated on the law. I don't believe any of them really understood what it means, prove beyond a reasonable doubt.
Herman Lindsay is the executive director of Witness to Innocence, an organization led by death row exonerees advocating to abolish the death penalty. So it turns out a lot of us in the general public have some knowledge gaps on this issue. For example, I thought the Constitution guaranteed the right to a jury of my peers. But in fact, the Constitution only ensures an impartial jury. Legal scholar James Banal says that over time, the courts have defined what that means.
What they've mandated is that the pool must be a fair cross-section of the community.
So the pool of potential jurors who are summoned to the courthouse needs to represent the diversity of the community where that trial is happening. The actual jury that's selected from that pool does not.
And so when you see a jury that is, say, all white and it's a black defendant, let's go back a step and let's look at the pool they were drawing from. Now, if you have a pool of 98 white folks and 2 African-American folks, well, then that's a problem if you're in a predominantly African-American area.
But he says if the initial pool of potential jurors was representative of the community and the final jury just happens to be all white, well, the courts have said that is legal. Now, what if a whole swatch of people in a community are automatically left out of the potential juror pool? That's actually what happens in half of U.S. states and the federal justice system, where convicted felons are permanently banned from serving on juries.
I think what this does, generally speaking, and I don't think there's any question about this, it removes folks of color from juries at a higher rate, and it whitewashes juries.
That's because a third of black men in the United States have a felony conviction. That's 3 times higher than the average for all U.S. adults. And it's a disparity that's tied to America's history of inequality in policing and sentencing. But since most of us don't think of jury service as an important right, not like voting, say, Banal says there's not much public debate about whether excluding felons from juries is a good idea. In fact, most people don't even know it's a thing. Banal himself had no idea until he got caught in California's felon juror exclusion law.
I was charged with DUI homicide, and I was charged with DUI aggravated assault, and I was sentenced to 3.5 to 7 years in prison. Ultimately spent 4 years, 1 month, and 6 days inside.
In college, he drove drunk, and the friend he was with died in the crash. While in prison, Banal applied to law school and graduated a few years after he got out.
2008, I was licensed to be an attorney and started working with a solo practitioner criminal attorney in San Diego who does federal work. A year later, almost to the day, I got a jury summons to serve at the San Diego Superior Court. When I arrived on the day of service, I had my new attorney card, right, my bar card. And so there's a special entrance for attorneys. And so I used that entrance. And I felt very privileged to be able to do that. So it was very much, this feeling of, I've arrived, I'm different. I have outrun this criminal past a little bit, I felt validated, right? And so they put us in a room in the jury lounge and they played us a video. And the whole video is about how wonderful it is to be a juror and how important it is and how this is such an important civic duty. And then after they played the video, they handed out juror questionnaires. The clerk said, okay, we're going to go through the questions. Who answered yes to question 5? Well, at the time, that question read, have you ever been convicted of a felony or malfeasance in office? She said, okay, if you answered yes to this question, please stand up and go to the back of the jury lounge and talk to the person at the window. You will be dismissed and you won't be called again. And so I went to the window and asked the woman, what's happening? And she said, look, you have a felony conviction, which means you will never be called again and you're permanently disqualified from serving as a juror in California. And I said, but I tried a case with the attorney I work with up the hall a week ago. And I came in through the attorney entrance, like I'm an attorney. Doesn't that seem a little illogical to you that I could do one thing but not the other? And she said, look, I don't make the rules. And if this is something that you're concerned about, write your congressperson. Rather than do that, I started doing empirical research on this, why we do it, what the effects of it are, and ultimately ended up in a book and a PhD.
That book is called 20 Million Angry Men, The Case for Including Convicted Felons in Our Jury System. Maine is the only state in the nation that allows felons to serve on juries without restriction, says Banal. 26 states permanently exclude felons from juries.
In the rest of the states, there are varying levels of restrictions. So some might have to wait till they're off parole or probation. Some might have to wait till they're off parole or probation, and then another 5, 7, 10-year waiting period. Some, it goes by a specific crime, right? Like in California, we changed the law, but there's still carve-outs for folks with certain crimes and certain statuses.
So what is the justification? What is the argument for not including felons on juries?
Generally two, identified in the literature. The first is the idea that if you have committed a crime, that you have revealed a flaw of character, and that you lack the ability to make good decisions and follow rules. So if we put you in that room and you are deliberating with the other 11 folks, you will not follow the rules. Maybe not jury instructions, maybe not sort of deliberation decorum. So we're worried about that. The second is the idea that we all harbor an inherent bias, and that by virtue of us having been labeled a felon, that we will, the argument is, unduly sympathize with criminal defendants and harbor a continuing animosity towards the state. And so if we're put in a position to serve, the logical conclusion, that argument, that we will hang every jury we're on. Those are the two functional sort of justifications, practical justifications for this. And those are the ones cited by the court often.
I mean, I will admit that in both cases that they sound reasonable. You have concluded otherwise. How? How have you been able to determine what would actually happen if a convicted felon were to be on a criminal jury?
So we ran mock jury experiments where we mixed folks who didn't have a felony conviction with folks who did. And we asked them to view a criminal trial, and then we asked them to deliberate, and we recorded all of it. And what we found was that these folks performed admirably as jurors. In terms of how they executed their duties, they did very well. In terms of how they behaved, that too was exemplary. There were conflicts that were productive conflicts. Where maybe someone who didn't have a felony conviction got a fact wrong about the case, where someone with a felony conviction corrected them, and there was a sort of thank you, I appreciate that, right? There was very much cooperation. There was no friction, right, or conflict that wasn't productive when we analyzed the trial transcripts. And on the sort of functional side, they raised more novel case facts, and they spoke for a larger proportion of their jury's deliberation time than did their non-felon counterparts.
Were they also, though, very sympathetic toward the person who was on trial?
They were not. We gave folks a pretrial bias survey to see whether they would, going into the trial, favor the defense or the prosecution, which is what the claim is about folks with felony convictions. These were all folks that were within 30 days of being out of prison. So we thought, well, if this bias is going to present, it's going to present most strongly with folks first out of prison, I should say. And so we tested it, and we compared folks with felony convictions to just general folks who are eligible for jury service. And then we actually included a group of law students in that survey. And what we found was that in terms of whether you're pro-defense, pro-prosecution, that yes, folks with felony convictions were more pro-defense than their non-convicted regular folks counterpart, but that when we included law students, that their scores were statistically analogous.
So law students were just as likely to favor the defendant as convicted felons were. And we don't exclude law students from the jury pool. So why felons, he asks. Banal's research also showed that members of law enforcement had a strong bias in the opposite direction, in favor of the prosecution. Police officers, in fact, are barred from juries in 5 states.
To be clear, I'm not in favor of them being restricted either. I mean, the jury has a process for weeding out people who lack character and who are biased, and that's jury selection.
This is the voir dire process that we talked about earlier. In order to get an impartial jury, judges can dismiss any juror they believe is unable to be impartial. So if a convicted felon in the jury pool were clearly biased, that's the fix, says Banal, rather than excluding felons out of hand.
I think the problematic piece of this is that we just don't use the process that's been in existence for over 100 years that we say is appropriate for every other demographic except for us. My whole work is open the jury room, bring in as many voices as we possibly can have, because that's what lends itself to a robust debate. And if we're ultimately trying to get to the truth, I think folks with diverse opinions get us there faster than folks without.
Tell me more about that then. The diversity is the goal there, diversity of opinion, or is it more so than impartiality, would you say?
Well, I think when the juries, years ago, we sort of thought of jurors needing to be, what folks called, right, tabula rasa, and the idea that they were going to come and be blank slates, and that they were going to either not have any preconceived attitudes, beliefs about anything, or they were willing to sort of leave those at the door and not bring those into deliberations, which is, for a human being, arguably impossible. So it was a fiction. There were no people that had no prior experience at 18 years old, right? And there were no people who had prior experiences that could categorically shut those off, Men in Black style, when they went into the deliberation room. So I think what people who study juries have come to realize is that that was fanciful. And what reality is that the room should be a mixture of folks with diverse experiences, diverse opinions, not so much so that they will be impartial, but enough so that this mixture of opinions ultimately creates a robust debate and gets us to the truth of what we're trying to figure out.
What would it have meant for you what would it have done for you to have been allowed to do jury service, or at least to move to the next pool?
I don't know, because I didn't get to do it. But the sort of mirror of that question was, what did it do to me to be excluded? Which was devastating. I mean, as someone who had, felt like I had rebuilt my life, to be told that, I could be an attorney representing someone in a death penalty case. The state had no issue with that. But the state had an issue with me serving as a juror, even in a minor fence dispute between neighbors that amounted to $5,000, right? So when we talk about folks desisting from criminal activity, one of the crucial pieces of that is that they have to adjust how they view themselves. Do you view yourself as sort of quote unquote criminal first, or do you view yourself as something else first with this thing in your background? And what happens when we have these permanent exclusions, and when we're telling folks that they're just simply not good enough to do something, in this case with empirically invalid reasons, what that does then is it makes that shift even harder, because I'm being reminded that, hey, you might walk in this courthouse through the attorney's entrance thinking that you're an attorney first, but when you got to the jury lounge, what I was made very clear to me was that I was a felon first and a lawyer second, right? That caused me, tumult and to question whether this was the profession for me, question whether this was something I really wanted to pursue. Clearly, they didn't want me in the club, was sort of how I thought about this. And I think that's how a lot of us think about these types of collateral sanctions, collateral consequences that are permanent based on your record. I think that the idea here is that folks who have this experience have value, right, and bring a perspective that isn't represented in a lot of context. And bringing that to these contexts only can enrich what we're talking about, right? It doesn't undermine it, and it doesn't make it less valuable.
James Banal is a lawyer and professor at California State University, Long Beach, and he's author of 20 Million Angry Men, the case for including convicted felons in our juries. Okay, next, I'm going to tell you why my jury service experience left me so frustrated and skeptical about the process. I talked it through with an expert, and she had some ideas for bolstering the jury system, so we'll hear those too. This is Top of Mind. I'm Julie Rose. Hey folks, it's Julie. Can I recommend quickly another podcast I think you're really going to dig? It's called A Braver Way with Monica Guzman, and it's from our friends at Braver Angels. You've heard Monica on Top of Mind before, talking about how to engage with perspectives you really disagree with. And each episode of her podcast, A Braver Way, introduces us to people from across the political spectrum who are taking the toxicity out of our politics, not by watering down their convictions, but by letting them clash and come into conversation. I know, it sounds impossible, but every episode of A Braver Way surprises me. And the goal for their current season, which I love, is to help us face this election year without losing heart. So, Check out A Braver Way at braverangels.org/abraverway or by searching for A Braver Way in your favorite podcast app. Now, back to Top of Mind. So I had never thought much about this issue until I got summoned for jury duty, and I was shocked by how the whole thing played out. All my notions of a noble process where 12 strangers come together and reach a unanimous decision through careful deliberation were dashed. So here's what happened. The trial involved a Black man in his 20s, charged with possessing a firearm as a convicted felon, which is a federal crime. Police pulled him and his passengers over. They found a gun in the car. He said it wasn't his. But at the trial, we never heard from the defendant himself. And his attorney did not make much of an argument other than to tell us that the gun wasn't his client's and the police couldn't prove it was. The prosecution, on the other hand, played clips of a recorded call the defendant had made from jail, where he seemed to be talking about the gun, though it was kind of vague. The rest of their case was built on police testimony about where and how they found the gun and what the defendant and passengers had said at the scene. Within just a few hours, we were in the jury deliberation room, and immediately we took a secret ballot vote, just like we'd seen juries do on TV. 11 of us said we were ready to convict. 1 did not. Soon, that juror revealed his identity and explained how, as a Black man, he didn't trust the police because of experiences that he'd had. And since every piece of evidence was from police testimony or police records, he just had too many doubts to convict. That snowballed to include a few other jurors. So after a few hours, it was clear that we were stuck. But the judge told us he would not allow a hung jury. He told us our job was to reach a unanimous verdict, and he sent us back to deliberate. At that point, we were focused on what we could agree on unanimously. And because it was clear that we could not unanimously agree to a guilty verdict, we ended up acquitting. It's a strange twist of logic I am not proud of, especially when most of the jury, including me, still believed the defendant was guilty. I have never told this story publicly because I've always felt like I failed. And I've had a lot of doubts about the merit of juries in our justice system ever since. So, to lean into the discomfort a bit, like I'm always encouraging our listeners to do, I wanted to hear the upside of the jury system. What's the argument for it? We called up Cornell Law Professor Valerie Hantz, who is a leading expert on juries. And first she explained why the American colonists were such fans of a trial by jury.
In the colonies, the English judges would come over and preside over trials, but the juries were other colonists. So they had much better understanding of the context of the environment, whereas the judges who had parachuted in from England were not that aware of those things. And there were also political trials that involved fierce struggles between England that wanted control and power over the colonies and the colonists who wanted self-determination. So the benefit of having a jury in a trial was apparent to them, and it carried over to the creation of the Constitution.
But today, as we have noted, jury trials are going extinct in the U.S. Only 2% of federal criminal cases use a jury. That's a serious loss, says Hantz.
I mean, after all, when you have a jury trial, it's in public. People from the community, not just the jurors, can go in there, can observe the government making its case, the defense making its case, and there's a transparency to the resolution of that dispute that we just don't get when parties by themselves resolve the case or people just lump it and don't even bring a case to the courts.
But does it really turn out better for the trial itself? I mean, why wouldn't we leave the decision up to the experts, to a judge, for example, who has, legal knowledge, can interpret the evidence, understands the law?
Well, judges are often appointed for many years, and sometimes they become jaded. They might become somewhat cynical. They may have seen the defendant before in a prior case, and juries give, at least in criminal cases, the defendant this benefit of a fresh look. The jury is able to bring representatives who can make a decision that's consistent with the norms and values of the community. So it is, I think, a way in which we've got a system that keeps the kind of legal system in touch with what is happening in the community. But I think, beyond that, there are ways in which it educates jurors about what actually happens in the law. And this is one of my colleagues and collaborators is a guy named John Gastel. And one of the things he found was that people who were very low propensity voters, people who, I guess, don't keep up with the news, they vote occasionally, maybe an occasional presidential election, but nothing in between, for example, were called for jury duty and were more likely to vote in subsequent elections after they had served on a jury. In other words, juries give us experience in self-governance. And once you've had that experience, you're more likely to do similar kinds of things.
One of the things that I've really been thinking about is that it seems entirely unreasonable for everyday people to be able to go into a jury room and set aside any of their own preconceived biases. So at this point, I put all my cards on the table and told Valerie Hans the whole jury sob story, mostly to explain why I was struggling so hard to really believe that a random group of nobodies, that's the word I used, could really do such an important work.
Well, first of all, I'm so sorry you had a negative experience. That's not usually the case. Most people go into their jury service thinking, oh, how did I get roped into this? But actually the experience of evaluating the evidence and discussing it with other people turns out to be a positive one, and one, that's kind of democratic self-governance. Your experience, to me, this actually sounds like a failure of the jury selection, that people who are so closed to a particular kind of evidence that's going to be presented, in your case, police evidence that's going to be presented, really can't judge the case fairly. And it sounds like in your case, there needed to be more extensive jury selection so that the attorneys and the judge could really assess whether or not people were going to be closed-minded once they got into the deliberation room.
So if you were to allow for more selectivity in the jury selection process, wouldn't it also make it harder to create a racially diverse panel of jurors? I mean, the fact is that if the question were, have you ever had a negative experience with law enforcement, the data suggests that, people of color, especially men of color, are going to be more likely to say yes to that. Therefore, they'd be more likely to get dismissed from the jury. Is that any better, really? I mean, is it any better to have only people who trust the police deciding whether or not this individual should be found guilty?
Yeah, well, it's really not so much about trusting the police, but it is, are you open enough to the evidence that's going to be presented in this trial? I think that's the question that the lawyers and the judge, well, at least the judge is aiming for. The lawyers might just be looking to see who's going to be on my side and can I possibly get a jury that includes more people on my side, or at the very least exclude people that I think are going to be so favorable to the other side they're not going to be open. But in terms of police and representativeness, if you have a community like ours is, where police actions fall more heavily on some groups as opposed to the others, you really have to do a balancing act between ensuring that you are not simply removing people because of assumptions about how they're going to treat police testimony, but instead their actual biases. It's tricky.
Professor Hans also says the jury that I sat on might have started out on the wrong foot.
I think the juries that function well often don't start with a vote. I'm not sure if you're...
We absolutely did. Yeah, we needed to know where we stood. And that's how we found out we had one holdout. And then that became 2. And then that became 3. And then we were stuck.
Starting with a vote is... I think research suggests that it can be counterproductive, because one of the things that happens when you're all out there raising your hands and expressing your views to other people about this is what the verdict should be, or that's what the verdict should be, you are expressing a view publicly that sometimes is hard to back down from. And one of the more productive ways that juries can engage is to talk generally about the evidence. It's a form of discussion called evidence-driven deliberation, as opposed to verdict-driven deliberation, which it sounds like what you had. So in evidence-driven deliberation, you'd look at the evidence generally without yet coming to an idea about what the appropriate verdict would be. So in a way, you, as a jury, develop a collective account of what happened in the case. And this is where, kind of above and beyond kind of the persuasion element, you are actually sharing, educating, correcting sometimes. Some people misremember evidence, and other jurors can assist in generating a factually accurate account of not only what happened at trial, but what happened in the original case and the original setting that led to this particular trial. If you start that way, then I think, you're able to evaluate evidence collectively and all contribute to that. And so I could imagine a very different path than the one your jury took. One more thing I want to add about your case, and that I think you got what is sometimes referred to as an Allen charge. And that is, you're the jury, you've been listening to all this evidence, no other jury is going to do it any better than you can. So get back in there and decide the case, right? Did you get some sort of instruction like that?
Yes, that's basically what the judge said. Do more work.
That does not mean that 10 jurors should give up. You want an instruction that tells people, look, we really want you to try. Please try. But don't compromise what you think is really the right outcome in the case. Some people think the Allen charge is actually too coercive. And the kind of thing that you were describing, where 10 people said, okay, the minority is not budging, so the majority of us, we are just going to have to give in. That shouldn't be happening, right? Yeah. You want the majority to be saying, okay, look, I'm sorry, we are going to have to be a hung jury here.
Well, we had no idea what we were doing, Many times during the course of our experience, I wished that we had some sort of a manual, or even better, I wished we had like a coach or some sort of mediator, like a guide. Like, I don't know, I don't think any of the people in that room had been on a jury before, so we had nothing to go on, and there was nobody to ask. And that felt really frustrating to me. Like, if there are best practices, couldn't juries know those? Isn't there a way to help juries function more effectively?
You're absolutely right. I think judges hold back because of this belief that the jury should be independent, that they really respect the jury's independence, and they don't want to tread on the jury's self-determination to conduct the deliberation in the way that the jury wants. But as you point out, a lot of people are on a jury for the first time, and they are thrown into the room and told, hey, go in there and please come out with a verdict. And so it does give the jury a lot of independence, which, has been so critically important in the United States since the very founding of our country. And yet it also at times leaves jurors kind of throwing up their hands saying, oh no, how do we do this? What do we do first? How should we go about this?
Hans says allowing jurors to ask questions could also make a difference. That's a change some states have embraced already.
Arizona and a few other places do permit this, and it's under very controlled circumstances. So the lawyers go first. That's their job, right? First examining the witness and then cross-examining the witness. If the jury at the end of their presentation still has questions that they would like to pose, they can submit those questions. Typically, they are written down and handed by the foreman or foreperson to the judge. The judge will then, most of the time, will invite comments from the lawyers about is it okay to ask this question? Or does it completely violate your approach to this case? But also will apply the rules of evidence. So it's worked pretty well in Arizona, and jurors themselves absolutely love it because it's impossible for lawyers to really anticipate all the questions that jurors might have about the evidence. And sometimes lawyers who initially are very negative about the idea that jurors are going to be supplementing their own work, after seeing it in practice, actually say, oh, actually, it was very helpful to know that the jurors had that question because now I can address it not only with this witness, but as I think about how to summarize the strengths of my case for the jury.
So, Professor Hans, what other recommendations do you have for shoring up or restoring, maybe is the better word, the jury system in the United States?
I'm a big fan of larger juries and also juries that have to be unanimous. Smaller juries are not as representative of the community as larger juries. I mean, there's a kind of miraculous feature of jury size 12 in that in a community with it often produces reasonable representations of the different voices of a community. The Supreme Court has taken care of jury unanimity by recent decisions that hold that any case in any serious criminal case that's heard in either a state court or a federal court, the jury must be unanimous. And the downside of unanimity is exactly what you experienced in your case, where you had a couple of people who were not in sync with the majority of the jury. But the benefits of unanimity are everybody's there, everybody's voice has to be heard. And I think that's really the key, because I think a big strength of the jury is this diversity of voices that is required to discuss and deliberate with each other. And in the vast majority of cases, it does actually result in a verdict that people can support.
Valerie Hans is a professor of law at Cornell University and expert in the jury system. Thank you so much, Professor, for taking time with me.
I found it really fascinating. Thanks for sharing your jury experience, too.
This was pretty cathartic for me. I'm sure you could tell, right? All of those conversations expanded my perspective, and while I don't relish the prospect of doing jury service again, I definitely have an idea of what I could do differently. I'd love to hear your thoughts on today's episode. Have you served on a jury? Has this episode made you think about them differently? Or do you just want to chastise me for the way things went in my case? Our email is topofmind@byu.edu. We'd love to hear from you. And be sure to check out our companion podcast, Uncomfy, where people tell us their own stories of choosing to stay curious and stick with the discomfort of a challenging perspective or situation. You can watch Uncomfy on YouTube, Spotify, and the BYU Radio app. Top of Mind is a BYU Radio podcast. Today's episode was produced by Vanessa Goodman, Elena Beck, and James Hoops, with help from Samuel Benson, Sam Payne, and me. Our engineer and sound design team includes Kelsey Ney, Gabe Vargas, and Brandon Lewis. I'm Julie Rose. We'll talk soon.